Q.6 The Unlawful Activities Prevention Act UAPA evolved over the years by a gradual but steady constriction of fundamental rights. Examine and provide suggestions to make UAPA more citizens' right friendly without compromising on anti-terrorism activities. Answer: Unlawful activities prevention is aimed to make powers available for dealing with activities directed against the integrity and sovereignty of India. Evolution of UAPA and how it constricted FRS. The evolution of Unlawful Activities Prevention Act UAPA has to be seen in the background of this gradual but steady constriction of Article 19, which guarantees the fundamental freedoms of expression, assembly and association. 1. The UAPA, 1967, UAPA gave powers to the central government to impose all India bans on associations. The process of banning associations could simply be done by the government announcing them as unlawful and hence banned. Section 3. 2. The 2004 amendment, changes to the definition of unlawful activity, included the definition of terrorist act and terrorist organization from the repealed POTA, and also introduced the concept of a terrorist gang. 3. The 2008 amendments AFTER, the 2008 Mumbai terror attack, more provisions similar to POTA and TADA regarding maximum period in police custody, incarceration without a charge sheet and restrictions on bail were incorporated into the UAPA. 4. 2012 amendments EXPA and EED the already vague definition of terrorist act to include offenses that threaten the country's economic security. 5. Ideology, like the TADA and POTA, UAPA also criminalizes ideology and association. By virtue of declaring an organization unlawful or terrorist and banning it, these acts have de facto criminalized their ideologies. 6. Association and possession of any literature of such an organization or even upholding an ideology common to that organization in the absence of any violent act is construed as an offense. On the other hand, mere membership or association with such an organization becomes an offense. 7. Vague definition. The HE Act introduces a vague definition of terrorism to encompass a wide range of non-violent political activity, including political protest. It empowers the government to declare an organization as terrorist and ban it. 8. Detention. IT allows detention without a charge sheet for up to 180 days and police custody can be up to 30 days. It also creates a strong presumption against bail and anticipatory bail is out of the question. It creates a presumption of guilt for terrorism offenses merely based on the evidence allegedly seized. 9. Courts. The HE Act authorizes the creation of special courts, with wide discretion to hold in-camera proceedings and use secret witnesses, but contains no sunset clause and provisions for mandatory periodic review. The low conviction rate under the Act and for instigating the riots at Bhima Korjayan under UAPA point to the abuse of the provisions of the law for stifling fundamental rights. To make it more citizen-friendly. 1. Sunset clause, which sets a deadline when the law will be repealed after peace arrives. 2. Mandatory periodic review. 3. Supreme Court. In 2011, the Supreme Court attempted to narrow the scope of these provisions, holding that membership was limited to cases where an individual engaged in active incitement to violence. 4. Change in the legal culture, with the courts following the example of the Bombay High Court in the first Kabir Kalamanj case, and granting bail unless the state can produce some cogent proof of criminality. 5. Accountability mechanisms, for officers investigating terror cases. 6. Anti-torture law, will prevent use of torture as a technique of